Hi everyone, today we're going to be talking about case law, the third and final part of our topic 3, lawmaking. So as we all know, case law is law made by the judiciary or the judges. So before we start, I just want to go through what exactly, when a court case is brought before a judge, what issues are involved. The first issues are issues of law. So these are the questions only judges can decide because they have the legal training and expertise to deal with these issues of law. So they refer to interpretation of statutes or legislation or laws made by Parliament. So that when they have a case, they look at the statute law and think, okay, how are they breaking the law and all that sort of thing. And then they look at the application of judicial precedent. So how do past decisions impact on this current case? And they consider, do there need to be new laws made for this case to be actually properly adjudicated? And so a question of law is decided by applying an existing precedent or creating a new one. Questions of law therefore commence the foundation of the case law process. So the only way we can make more case law is by disputes coming before the court, applying or reversing precedents from previous cases. So for example, a man might trip over a faulty paving laid by the local council and injures himself. The issue of law in this case would be to decide whether or not the man has a legal cause of action against the council. So did they actually owe him a duty of care? Do they owe him a legal duty of care as the council would be the question of law in this scenario. The other thing is the issues of fact. This is quite different and this can be decided by a judge or jury in a criminal case. So these questions determine the facts of the case and the truth of the allegations made by the plaintiff or by the prosecution. And issues of fact are brought about by, getting evidence from witnesses, second-hand evidence, first evidence, and so on, to decide whether these facts are true or not. In civil cases, only a judge can determine the facts, whereas we know in criminal you can have a jury to decide as well. And of course, these must meet the standard of proof. So, is it beyond reasonable doubt that the allegations are true? And so using the same example, if the court finds that there's a legal case for the council to defend, the issues of fact will be to decide whether the man actually tripped and was that trip the cause of his injury. So the fact here is whether he actually did trip and whether it was the paving that was responsible. That's not a law issue, that's a fact issue. Moving on, so what exactly is case law and how is it made? So judges make case law in a similar manner that a bricklayer builds a wall. The first case is often referred to as a landmark case, so it's the first of its kind, and it may commence a departure from an existing branch of law or create a whole new body of law, much like the tort of negligence. So the first case acts as like a building block that other judges will follow if the facts are similar in the case. And so as other cases are decided, the legal principles created in the landmark case are broadened and developed. So the tort of negligence started from a snail in a bottle, and that's been broadened to so many more things of, having a duty of care to a legal neighbour. And so each case kind of makes a new brick in this wall. Over time, as more cases come before the court, judges will build a body of case law, just as the bricklayer completes a, brick wall from individual bricks. So, yes, that's kind of the main process. Cases come before the court and cases generally can be quite similar, and judges make law in response to these cases. So, as we know, the Donahue v. Stevenson example, where this invented the tort of negligence in 1932. Since this case, thousands of similar cases have broadened and developed the elements of negligence decided by the House of Lords, such that the new law negligence law has a kind of solid wall of settled decisions that guide all courts when hearing cases about negligent behaviour. So not only do we follow the Donahue v. Stevenson principle, but all the ones that followed it and have been upheld as well. So how is it made? It's only made when a case is brought before the court. Judges can't just get together and think, oh, yep, let's make some new case law. It doesn't happen that way. only when issues are brought before the court, and it's made in two main ways. The first one is probably the most obvious one, is that when they make decisions, they set a precedent. So they make and set judicial precedents, and these are considered one aspect of case law. So if they're going to decide that Jahan is guilty of stealing the school stapler, whatever, from the library, that's going to set a precedent for anyone else who tries to steal school property. Okay? The second way they make case law is by giving meaning, so to the words, to statute law through statutory interpretation. So as they have to deal with issues of law, they inevitably interpret the meaning of the statute Parliament made law to justify their decisions. So, and this will often be recorded in their judgments, how they interpreted the statute in relation to the case. So the two ways it's made are by precedent and by interpreting statutes. Case law is also heavily reliant on this idea of the doctrine of precedent, which means all like cases must be treated in like ways, as well as precedents of higher cases being followed in lower courts, which relates to the court hierarchy. Now, when a judge makes a decision, there are two components that must be recorded and just elements of the decision. The first and probably the most important one is another Latin term called the ratio decidendi. In Latin, this means just simply the reason for deciding, or the reason for the decision. Ratio means kind of like rationale, and decidendi means decision. So rationale for a decision. It's the principal factor in the process of reasoning leading to a precedent. So this is my reason, and this reason is going to stand for following similar cases. Every court decision embraces a ratio decidendi that lower courts in the same hierarchy are compelled to follow in accordance with the common law doctrine of precedent. So inferior courts follow the decisions of superior court. The reasons for the judgment are obligatory because every court decision is subject to appeal. So you have to give a ratio decidendi to allow the appeal process to happen. And so, for example, in the Donahue v. Stevenson case in 1932, the ratio decidendi was that a duty of care was owed to a legal neighbour. So they introduced these principles of duty of care and legal neighbour as a reason for the decision. The other aspect of a judgment is the obiter dictum. This is kind of less obvious, but this refers to the remarks in passing that the judges make. So these are judicial observations made by judges to support the logic of their ratio decidendi. So we've made a reason, this is the reason for the decision, and this is why we've made it. But importantly, this obiter dictum does not form the binding part of the precedent. So the ratio is binding, it must be followed by lower courts, whereas the reasons for the decision don't have to be, remarks which support the logic of this don't have to be followed. So for example, the High Court of Australia in 1992 referred to the native title concept in the USA and Canada to help them make this decision in the Mabo case. They didn't have to follow the USA and Canada obiter dictum, but it was quite impactful in making the decision on Mabo. So now it brings us to the ideas of the doctrine of precedent and stare decisis, another Latin principle or term. So the doctrine of precedent is a judicial practice which kind of prescribes that every inferior court must follow the decisions made in a higher court within the hierarchy. So within the SA hierarchy, all higher courts' decisions are binding on the lower ones. It also prescribes that a decision of a court in a different hierarchy can have weight, but it's not binding but persuasive. So, for example, if the Victorian Supreme Court were to make a decision, the South Australian Supreme Court does not have to follow that. It's persuasive because it's a different court hierarchy. Same with, a decision made in Queensland. Say if the Queensland Supreme Court makes a decision, the SA District Court does not have to follow that. Another aspect is that only the ratio of a case is binding like I said before. And any other relevant decisions, such as their beato dictum, are not binding, they are persuasive. And precedents, importantly, do not lose their legal status. So they are, much like statute law, they are indefinite and will only sort of be invalid if declared invalid by the Parliament or the judges themselves. Secondly, the idea of stare decisis. It means literally stand by the things decided. So we've made a decision earlier, we should try and follow this. It's a common law principle which kind of has the aim of predicting outcomes of cases that are similar, and importantly maintains consistency in the delivery of justice. If you didn't stand by past decisions, it would just be kind of arbitrary and a lacking of consistency and sort of predictability in the process of legal dispute resolution. So that's stare decisis. Now, quickly, we touched on binding and persuasive precedents. So what is actually the difference between these? As their names imply, a binding precedent, it must be followed in all lower courts in the same hierarchy with similar facts and circumstances. Binding precedents are also created in superior courts, not in inferior ones like the Magistrates' Court, for example. So, for example, an original precedent created in the High Court, the full bench, like the concept of native title, binds every other court in Australia. Every other court must follow the ratio of this decision. Persuasive, on the other hand, they're more like a guide, and they're not bound to be followed. These include things from inferior courts. So the Supreme Court in SA does not have to follow the Magistrates' Court's decisions because it's inferior. Also, precedents made overseas, so America, England, they're persuasive as well. We don't have to follow English court decisions because they're not part of our hierarchy. And again, the idea of Mabo comes up as an example for persuasive precedents. And as I said earlier, decisions made in other states are only persuasive in SA courts. They're not binding. Interestingly, in 1978, because you used to be able to go to the Privy Council, which is this highest court in England. It's kind of like the High Court in England. And it used to be the highest place you could appeal. And people did that. People from Australia appealed their cases to the Privy Council in England. And in 1978, this was actually severed and abolished. So the Commonwealth Statute severed appeals to the Privy Council, which means that all British court decisions are only persuasive from this point on. That's all from me today, guys. For the rest of the lesson, I would please like you to complete the case law activities worksheet on Google Classroom attached to this post. It involves some tables and some filling in word blanks. If you don't complete it during the lesson, please finish it off for homework before tomorrow so we can discuss it. Thanks, guys. Email me any questions you have and get the work done.